Hello everyone, I'm Prachi Bhardwaj and I'm here with the top must-know Supreme Court judgments and stories from the month of February. But before we begin, all of us at SEC Online would like to wish you all a very happy and colourful Holi. In the biggest news from the month of February, the Supreme Court achieved the sanctioned strength of 34 judges as 7 new judges took oath. Detailed reports on all the new judges about their career trajectories is available on the SEC Online blog. A 5-judge constitution bench of the Supreme Court has held that neither the original Advocates Act nor the 1973 amendment to it prohibits BCI to conduct pre-enrollment exams like the All India Bar examination, as it is directly concerned with the quality of lawyers that come into the profession. When a 5-judge constitution bench was posed with the issue relating to excommunication of Dawoodi Bohras, it observed that the decision which will be rendered by the 9-judge bench in Sabarimala temple review case will have a direct impact on the questions which arise for determination in this case. And hence it observed that it deserved to be tagged with the 9-judge bench Sabarimala review matter, wherein 2 out of the 7 questions framed deal with the rights of religious denomination under Article 26 of the Constitution and the extent of morality. A 5-judge constitution bench has reserved verdict in a case where clarification was sought by the Department of Military Affairs on applicability of the 2018 Joseph Shine judgment that decriminalized adultery on defense personnel as they function in peculiar conditions, being separated from their families for long durations. It was argued that in such condition there will always be a concern in their minds about the family indulging in untoward activities. In a very interesting case, a woman sought Rs 3 crores compensation, claiming that as a result of a bad haircut, she could not continue to lead normal life as she no longer looked pretty. She had to face great humiliation and embarrassment. Her career in the world of modeling was completely shattered, and that she went into a state of depression. NCDRC awarded her Rs 2 crore compensation, but without any material being produced by the woman to quantify the compensation. When the matter reached the Supreme Court, it held that whether or not she deserved that much compensation can be decided only when she presents material supporting her claim. Consequently, NCDRC will now decide the matter afresh. How often do we come across cases where the spat between husband and wife becomes so ugly that even innocent children are dragged into it? In one such case where the husband had accused wife of adultery and had sought DNA test for the child, the Supreme Court went all guns blazing to hold that a child cannot be used as a pawn in such divorce cases. The court clarified that DNA test can be directed only in exceptional cases where such a test becomes indispensable to resolve the controversy. In a case involving a 20-year-old young woman who moved the Supreme Court at a late stage of her pregnancy, the Supreme Court, as well as the law officers and the lawyer appearing for the woman, joined hands to deliver justice in its truest sense by asking the woman to go ahead with the pregnancy by ensuring her that the future of the child will be protected, as he or she will be adopted by a couple registered with the Child Adoption Resource Authority. This balanced order came after the woman told the court that she had lost her father during the COVID-19 pandemic and her mother is unwell. However, all of them showed their inability to raise the child with the due care that a child deserves. With that, we come to the end of our Supreme Court February roundup. A comprehensive roundup of not just these judgments and stories, but a lot more can be read on the SEC online blog. Keep watching, keep learning, and keep reading the SEC online blog for the best analytical legal news.